SJC-13036, Commonwealth v. Andrew M. Rossetti.
Okay. Attorney Schneiderman, good morning.
Good morning, Your Honors. May it please the court, I am Joseph Schneiderman. I represent Andrew Rossetti, and borrowing the baseball analogy, I am pleased to bat third this morning. Your Honors, for the last 40 years, this court has held that there are three ways for the legislature to create a mandatory minimum sentence, and none of them are present in the text of failure to register as a sex offender, subsequent offense. Indeed, the legislature actively repealed some of that language 15 years ago. First, the legislature says mandatory or minimum. That language is not in the statute. Second,
let me stop you there, Mr. Schneiderman. Let me stop you there. I want to know, is there a way in the sentencing scheme that you can have a sentence for a term of imprisonment that is required, yet it is not a minimum mandatory? So it's not minimum mandatory. It's not mandatory that he be sentenced to 5 years because he could also have probation, right?
that's correct, Your Honor. Yes,
So
he could have
it's not
probation.
really a minimum mandatory in that context.
Right.
That's correct, Your Honor. Yes.
Okay.
Actually, Your Honor, that leads to my second point, which is usually, or actually it leads to my third point. I'm going to take them out of order here. The legislature usually has language that regulates the availability of probation, parole, or credit for time served. And that is the language that the legislature repealed 15 years ago. And the Commonwealth agrees that probation is available here as a disposition. The Commonwealth's analogy to Brown and to the other cases cited there does not work because, to Your Honor's question, the statutes that create a minimum term usually give the judge some express guidance as to how to fix a minimum and a maximum term as the judge is required to do. And indeed, with all statutory construction, we assume that the legislature knows the statutes and the decisional law of this court. So by way of example, a statute that would create a mandatory minimum would be not less than 5 years, but no more than however many years. And the Commonwealth's analogy to Brown,
Mr. Schneiderman, would that also have a limitation on it on probation or those other alternatives? Would that also be included in a minimum mandatory, the option of probation?
No, Your Honor. The option of probation would preclude judicial discretion, or sorry, that's backwards. The unavailability of probation would be a minimum mandatory because it takes discretion away from a sentencing judge.
So, but here we have some discretion.
We do, yes.
But if he's going to be sentenced, it has to a term of imprisonment, it has to be at least for 5 years.
Not quite, Your Honor. That's the 40 years. In Lightfoot, almost 40 years ago, this court articulated that the phrase "not less than" is not by itself enough to create a minimum mandatory, even when combined with other language. And I think that premise is compelling because for the last 30 years, since the Truth in Sentencing Act, the legislature has abolished fixed state prison sentences, the former Concord sentence, as it was once known. So saying a "not less than" in a vacuum is not enough to give a judge guidance as to how to fix a sentence. And I think there's a compelling need for discretion here in light of the sheer number of ways someone may commit this offense. Registration obligation.
I could interrupt you for a moment because I'm not sure that you precisely got to Justice Cypher's point. You don't have the word mandatory. Okay, it's not a mandatory. You don't have the language necessary for there to be preclusion of probation. So probation's an option. But the judge wants to impose a sentence, I think, if I'm remembering correctly, of 1 to 2 years on one of the counts. The statute says 5 years. How can the maximum sentence, not the minimum number, the maximum sentence be less than 5 years? And doesn't Commonwealth versus Thomas, which is just this situation, resolve the issue that, well, the minimum is what the judge sets, but the maximum has to be at least 5 years.
Your Honor, I would distinguish Thomas in as much as the use of the firearm in a felony adds time to a predicate offense, unlike here, where this is a freestanding criminal offense and actually has all of the hallmarks of a freestanding trial just on whether someone is a subsequent offender. So I would suggest that Thomas reaffirmed Hines, which was the statute at issue there and that holding, but I think the judge still should have discretion to fix a maximum term in light of how many ways someone can violate this statute, and particularly in light of how not only is it easy to violate this statute, but this court does not infer harsh penalties for passive conduct. This statute does.
Let me just play your position back to you. The statute says that a second and subsequent conviction under this subsection shall be punished by imprisonment for not less than 5 years. And your position is that the judge can impose a 1 to 2 year sentence in the face of that language.
Yes, Your Honor. I'm sorry, Your Honor, was there something more?
No, thank you.
Well, can you explain the logic behind that?
Yeah.
Like I said, that's what I have more.
I would be happy to, Your Honor. The logic behind that is when the legislature wants to take sentencing discretion away from judges, it usually does so in the plainest terms. And
How do
they're
you
just
reconcile a state prison term for 2 years consistent with the language that says not less than 5 years? You're just saying stare decisis. We've said you need to use the magic words, and therefore, even though the legislature is saying not less than 5 years, it doesn't mean that.
the phrase "not less than 5 years," Your Honor, in a vacuum is not enough. That's my logical point, and that's
Not enough for what? Wait, not enough for what?
not enough to create a minimum.
Okay.
I realize not less than 5. I realize not less than 5 typically would be understood as just that, not less
Not less
than.
than 5, right?
But counsel,
Not
are you saying if that statute said not less than 5, but not more than 15, that if it were elongated to that you would be saying the opposite, that the minimum sentence that the judge could impose is 5 years?
Yes, Your Honor.
So to state it simply, because there's no maximum term, that can't be a minimum term.
That's correct, Your Honor. Because there's no maximum term, there can't be a minimum term. And indeed, the logic of that, to Justice Wendland's question, becomes compelling because of the myriad ways one can violate this statute. And there is a risk that one could be punished harshly for what is passive conduct. Registration obligations have.
But the legislature fixes these, then why did the legislature do what it did? They're the ones that set this penalty. I get your argument about how unjust this could be, but the legislature said this for a reason. What was the reason?
Your Honor, I'm not aware of specific legislative history as to this statute. However, the context of this statute was in 1999. This statute was passed at about the same time as the Jacob Wetterling Act. More to Your Honor's question, though, about text, 5 years can also be considered a shorthand. In other words, that a felony that's punishable by up to 5 years can be tried in the district court. And first offense has that language of not more than 5. I think
when you answered Justice Seifert's question about not less than, you said that it's understood not to fix a minimum mandatory, but here nobody's suggesting this is a minimum mandatory because the government agrees you could give probation, correct?
That's correct, Your Honor. Yes, the Commonwealth agrees with me. Yes.
Counsel, can I ask you another question? And that is that if we wiped out, if we just were writing on a blank slate and we had no previous SJC cases to look at to figure out what this sentence means, would you think we would just read it, the plain language as it is, and say you get 5 years or up, or you get probation? We'd no case law history interpreting what's a minimum mandatory. Would you agree with that?
Your Honor, if we had no history, we would actually have an ambiguity problem, because it would be not less than 5, but there would be no guidance, as Justice George pointed out in his hypothetical, there would be no guidance as to what the maximum is, and the
Well,
maximum
it could
would
be up to life. It could be life. Maybe it could be life.
It could be life, Your Honor, but then the statute potentially runs into constitutional jeopardy, in as much as the statute could be read to punish 5 years to life for what is essentially passive conduct. I think
Well,
this
that you
court
say
should be-
it's passive conduct, but in some circumstances, it certainly is, right? Some circumstances, absolutely, it's passive conduct, and absolutely, we don't have a terribly vicious, dangerous sex offender on our hands. But in some circumstances, it's not passive conduct, and we might have somebody who is a serial predator and might need reining in that way. Is that not part of what the legislator could have been thinking, the legislature?
Your Honor, I agree that the legislature could have thought of that, but I think there are other tools besides this statute that could have done it, especially the habitual offender statute. If someone is just utterly recalcitrant and is moving all over the Commonwealth, from Amesbury to Pittsfield to the Cape, and they rack up enough of these, and they are, as Your Honor is suggesting, dangerous like that, I think the sounder approach would be not just to try them as a subsequent offender, but under the habitual offender statute. And then the habitual offender statute, a judge could impose a hard
Failure
sentence.
to
but
register qualifies under the habitual offender statute?
It could, Your Honor, yes, because it's 3 years or more, as I recall the habitual offender statute. More to Your Honor's question, though, this statute, I think, if this statute were, as Your Honor is suggesting, if we were on a tabula rasa, this statute has to be considered in light of the law of sentencing as a whole, and how we have to have minimum and maximum state prison sentences if someone is going to go to state prison. We do not have determinate, tongue twister again, we do not have determinate state prison sentences anymore, and the minimum term fixes parole eligibility. I think not less than 5 years in a vacuum, then it becomes ambiguous. Lenity would kick in because it's plausibly ambiguous. And actually, to Your Honor's question, putting someone into this cycle of registration and imprisonment, as the amici have pointed out, would not actually further public safety. It would further isolation and would create another form of constitutional jeopardy by suggesting that this registration schema is punitive. I fully appreciate Your Honor's point that there are dangerous people who perhaps should be subject to the statute and perhaps should be taken off the streets. But the statute's purpose here is one of public safety. Public safety would not be served, as the amici have pointed out, by putting someone into a cycle of imprisonment, release, noncompliance, imprisonment, release, noncompliance. That could not be what the legislature had in mind when they passed the statute.
How is that inconsistent with just taking into account what our case law is and reading the statute to say that the sentence can't be, if there's going to be a sentence, it can be straight probation. If there's going to be a sentence, that the maximum can't be less than 5 years. It could be a 1 to 5. It could be a 2 to 5. It could be straight probation. But what I don't understand is how it can be a 1 to 2 when it says not less than 5 years. That I don't understand.
Your Honor, again, this is. I'm sorry, Your Honor. I didn't mean to false start like that. Your Honor, any state prison sentence must be at least a year. And I think the sound interpretation of this statute is that there has to be, for a subsequent offense, state prison time. I think 5, we're saying it has to be 1 to 5 or 2 to 5 or 3 to 5.
Or probation.
Or probation. I think 5, that would potentially be a bit of a sea change here. And I think this court, if such a sea change, should not come lightly. I see my red light is on. I think in the end, Your Honors, inferring that 5 years is the minimum here does not comport with this statute's text, purpose, or canons favoring lenity, and would cause more problems than it solves. I ask that this court answer the reported questions, yes, and I thank the court kindly for your time.
Okay, thank you. Attorney Blatchford.
Thank you. May it please the court, Howard Blatchford, Assistant District Attorney for Middlesex on behalf of the Commonwealth. As Justice Wentland observed in the first case this morning, words that we use to describe things really do matter, and as they do here in this case. This case does not involve a statute that requires a mandatory minimum sentence, as that term is used in the Hines and Lightfoot cases. The sentence prescribed by this statute, should the judge opt for incarceration, is a sentence of not less than 5 years, which is a fixed term of the least duration, but not a mandatory minimum sentence. Furthermore, it would be incorrect to say that the unambiguous phrase, not less than 5 years, is the minimum sentence under the statute, because the sentencing judge always has the option of sentencing the defendant to probation. There appears to be a lot of confusion in the use of these terms, and if I've misused them in the Commonwealth's brief, I apologize. But in thinking further about this and in preparation for the oral argument today, I think some distinction needs to be made in terms of what is a mandatory minimum sentence and what is a minimum sentence and what is a period of prescribed incarceration. The statute here is as clear as it could be. A second and subsequent offense shall be punished by imprisonment in the state prison for not less than 5 years. If the sentencing judge opts for incarceration, 5 years is the fixed term of least duration that he can impose. But this doesn't even mean that the defendant will serve 5 years, because the defendant would be able to avail himself of good time or any other credits that the Department of Correction might afford him. And those credits would not be afforded under the scheme in Hines and Lightfoot. This statute stands very, very distinct and apart from Hines and Lightfoot. It doesn't have that language that prohibits probation, parole, good time credit, and so forth. The statutes in those cases were very draconian. This statute is not. In fact, the sentencing formula used in this statute has been used widely in the case law. A Westlaw search for the terms not less than within 5 words of year and or indictment or criminal returned 133 hits alone under the Massachusetts statutes. It's a very calm sentencing scheme. Granted, the judge here, as other judges in other cases have observed, that they are faced often with a Hobson's choice of either sentencing a defendant to probation or to a term of incarceration. But as this court observed in Ontario last year, that is something that the legislature has set up and has often failed to resolve. In this case, where the choice is between probation and 5 years, the Hobson's choice, if you can call it that, is far less than what was the case in these other cases where it was 10 or 20 years. So it's less of a Hobson's choice, but still it's what the legislature has chosen. I'd like to comment briefly on a few other points raised by the defense and the amici. And with respect to these other sentences that have been imposed in the Commonwealth, and these were outlined in a chart on pages 27 and 28 of the defendant's amended brief. The Commonwealth chose not to address these when we wrote our brief, for the reason that we believe that it's irrelevant. If other judges are imposing sentences that are inconsistent with the statute, that's no evidence really that the statute should be construed in the way that those sentences were imposed. Careful examination of the docket sheets in these cases, which are available in the amended record appendix, reveals a few facts that I think were overlooked. And with respect to the Crevecoeur case, that's a Middlesex case in 2017, number 1681 CR 457. There's a docket entry there that reveals that it was a partial null pros as to the subsequent offense charge entered. So I can't say for sure, we don't have the transcript, but it would suggest that the sentence that was imposed of 2 to 3 years state prison was on a lesser charge than what's involved here. Similarly, in the Jenny case, which is on the recited or is noted on page 28 of the defendant's record appendix, that's Middlesex case also, 1481 CR 313, where 2 to 3 years in state prison was imposed. That sentence was not imposed for the subsequent offense failure to register. Rather, that was imposed on a charge of open and gross lewdness, the 2 to 3 years imprisonment, and the defendant received 5 years probation on the subsequent charge. Again, some of these other cases from other counties involve probation violations, and it's simply not clear from the docket sheet why these sentences were imposed. But I would suggest that if the court wanted to go there, and I don't believe it should because I don't think it's relevant, there may be reasons why the dockets reveal that sentences of less than 5 years were imposed that have nothing to do with this particular statute.
Counsel, could you address Justice Lowy's question to your brother counsel? Is there any interpretation of this that would set the maximum, that not less means that the maximum sentence that could be imposed was 5 years, and so therefore the judge either had to impose probation or 5 years, but can't do a 1 to 2?
I don't believe that's correct, Your Honor. I believe that where a statute does not provide a maximum term of incarceration, the maximum term would be life. And here in that case, the least amount of incarceration that a judge could impose would be 5 years, and life would be the presumed maximum. Obviously, that would raise issues were a life sentence imposed, but they're not presented in this case.
Okay, thank you.
A couple other points. The Amici note in their brief on the very last paragraph that there was prior in time a mandatory minimum, true mandatory minimum, if you will, that applied to this statute. What they don't note is that applied to a section C that was repealed in 2006. And that section C addressed punishment for any offender who lists a homeless shelter as his residence pursuant to various sections of this statute. And that section did include the language about no probation, no parole, no good time, so on and so forth. That was repealed. Clearly, the so-called magical language, if that's what's being referred to, referred only to that section C. That those terms were included in section C. They appear nowhere else in the statute. They clearly did not apply to section A2.
Can I ask you a quick question about Hines? Because I have trouble squaring Hines and Brown. Particularly Hines footnote 4 talks about Brown having both a mandatory, in contrast to the language at issue here, the language at issue in Brown dealt with 2 terms, both a maximum and a minimum term. Is that right? I thought there was only a not less than language in Brown.
That was my recollection also. And Brown pointed out that
So
the
how
not less than language has always been interpreted in the same manner, meaning that it means not less than denotes a minimum sentence.
Yeah, you see, that's where I get confused about how do we have to edit Hines here to get to your result? Because Hines seems to support defense counsel's position somewhat, but it may be a misreading of Brown. I
don't believe that this court needs to edit, if you will, Hines. I think Hines stands alone. It's a different statute. It contains those restrictions that are not included here. I think the court can answer these questions in the negative in this case without affecting Hines at all.
Do you think you can, and just give me again your paragraph that distinguishes Hines in the opinion. It should read as what? Go ahead. When we're writing this up, we say Hines is distinguishable because of what?
Statute in Hines contained a restriction on the judge's ability to sentence to probation, availability of parole, availability of good time credits, any other credits that might be available to the defendant until he has served the mandatory minimum term. And the court indicated that in those cases where the statute is so draconian, it leaves no way out for a defendant, that the words mandatory minimum must be included.
So
This is
here,
not that
because
statute, though.
here, even though it's a not less than statute, because it provides for probation, although it doesn't expressly provide for probation, right? It just, we've interpreted to provide for probation. Because of that, it's different from Hines.
Correct.
I'm sorry, you're saying the Hines statute was draconian. Was that the rationale in Hines? Oh, because it's draconian,
Because it
we're
was
not
draconian.
gonna read this as a mandatory minimum?
That the mandatory minimum words must be used so that it's clear that the legislature intended that that's what they wanted to do. But this statute does not.
Is that,
include
was that the
draconian.
reasoning, or was it Mr. Schneiderman's reasoning,
Yeah.
which is that because there was both a maximum and a minimum, you seem like you're rewriting Hines a little bit. Hines, didn't quite say that, did it? Didn't have this draconian point.
Well, the Hines statute included these draconian terms, and that's our attempt to distinguish this case from Hines, is that this statute does not include the draconian terms, and that it must have been in the court's mind as they were ruling in Hines that the mandatory minimum words must be used going forward to denote a mandatory minimum sentence. It was because of those draconian terms. Again, this statute does not contain the draconian terms, it allows the judge to sentence to probation. It would allow a defendant to get credit for good time. It would be unlikely, frankly, that absent some problem, the defendant, even if he were sentenced to 5 years, would ever serve that amount of time. It would most likely be less than that if he was able to get the good time credits. Your Honor, if there are no other questions, the Commonwealth would submit on its brief. The command of the statute is clear. There's no ambiguity. Both questions should be answered in the.
Okay, thank you very much.